Arguments, as you know, are being recorded, so please keep your voice up, remain behind the podium, and do not use names of any children, victims of crime. Judges have read your briefs and we are ready to see when you are.
Thank you, Your Honors. Well, my name is Sean Sergi. At the outset, I'd like to reserve 3 minutes for rebuttal. I represent the defendant appellants. They are Dr. Vladimir Moxon, Sophia Moxon, and App.No, Inc. I'd like to begin my remarks today by clarifying what is not in dispute in this appeal. What is not in dispute is that the payment on the promissory note in this case was supposed to begin in 2002. What is also not in dispute is that the final payment was supposed to be tendered in 2003. It is also not in dispute that the promissory note here is a note payable at a definite time, subject to the 6-year statute of limitations that applies to notes payable at definite times. It is furthermore not in dispute that Dr. Deuce did not seek to file a claim on the promissory note here until at the earliest February of 2019, when he sought leave to amend his complaint and add his breach of promissory note claim to this case.
Counsel, there is a dispute though, isn't there? I mean, I know how you said it, but there is a dispute as to when the promissory note was supposed to, you were supposed to give payment. And in the promissory note, it does talk about the holder of the promissory note being able to adjust the time schedule, basically.
Absolutely, Your Honor, absolutely. And the clause under which Dr. Deuce purports to base that right, that's the clause that appears sort of towards the bottom of the promissory note, or maybe about halfway, and it says that it allows the holder of the note to change or extend the dates of payment. So I suppose I want to make sure that the court is aware of the big picture, that there's a 15-year gap here. Ordinarily, we would say there's a 15-year gap. Statute of limitations is 6 years, and so this promissory note is well beyond that time. But to get to your question, Your Honor, you are right. There is that language, and we make 2 arguments about that language. The first is that the language does not mean what Dr. Deuce says it means. And the second is that even if you agree with him that it means what it says that it means what he says it means, that the clause conflicts with the statute of limitations, it is therefore void as against public policy. So we've got 2 arguments to that exact point, Your Honor. And let me begin with our first argument, which is that the language does not mean what Dr. Deuce says it means. And we think some background principles of contractual interpretation are important to keep in mind here. One is that you read the note in the context. You read provisions within the note in the context of the entire note. The second is that you cannot read out certain terms of the note. Courts ought to do the best to give effect to the meaning of every provision within the note. And the third is that courts apply ordinary common meaning in interpreting contractual language. So we think, keeping those principles in mind, that it is simply implausible that the note here would have established an 18-month continuous period of payments and then buried somewhere halfway in between in about 5 words say that notwithstanding that 18-month continuous period of payments established at the outset of the note, and keep in mind that the note calls itself an installment note, that's not a dispute, that nonetheless Dr. Deuce could have secretly, indefinitely, and unilaterally extended or changed the payment dates on this note, and with it the limitations period. In other words, Dr. Deuce's contention is that that language that you pointed to, Your Honor, allows him, notwithstanding the 18-month successive installments discussed at the beginning of the note, that he could have extended the payment dates on that note without telling anybody, all on his own, 5 years out from 2003, 10 years out. In this case, he claims to have done it 15 years out, and he's asking for interest all the way going back to 2002. But there is no limiting principle to his position. The logic of his argument is that he could have done the same 30 years out, 40 years out, 100 years out if he lived that long, or came up with some other argument for why he should be able to do that. and ask for interest throughout all that time. Your Honors, that reads out of existence the 18-month installment contract that is set up at the outset of the note. It's
Well, counsel,
implausible.
why couldn't it be interpreted to be that he has the option when to make the demand for the note to begin paying, for the creditor to begin payment of the note?
Why doesn't it, could you repeat that, Your Honor?
Why couldn't it be interpreted, I think I can repeat it, why could it be interpreted that he was in control of when demand was going to be made as to when the creditor had to begin the 18-month period of repayment?
I don't think that it could be understood that way because it was very clear from the outset of the note that the payment was supposed to begin in May 2002. That is clear on the face of the note. It's also not a disputed fact in this case. Dr. Dews agreed that everybody agreed that in May 2002, payment on the note was to begin. But, Your Honors, even if this language could somehow contemplate some type of an extension, what we take issue with is the notion that the extension could have been something other than a mutually agreed upon extension. Again, his argument is that on his own, Dr. Dews, without telling anybody, could have changed the dates of the payment. And again, we think that that is in conflict with the installment nature of the note. And we have offered what we think is the most plausible alternative explanation for that language. And that requires, of course, a recognition of the fact that this is fundamentally a negotiable instrument. This language that we've been talking about is included not just in this note, it is included in countless other promissory notes that are drafted perhaps every day in Ohio and in other jurisdictions across the country. And as many courts have recognized, and we've cited these courts in our brief, what this language is trying to do is invoke a UCC provision, a default UCC provision that would otherwise apply to this note, but for the inclusion of this language. The same is true, I would add, of the language discussing presentment, demand, notice of dishonor. Those are terms of art that one finds in the UCC. They don't really make sense here in the note if you just read it on its own, but they make perfect sense in this note and in many other notes if one recognizes that fundamentally this note establishes a negotiable instrument that could have been transferred from one holder to the other, that in so being transferred, multiple people could have been liable on the note, and in order to ensure that those people remain liable on the note, notwithstanding a potentially agreed upon extension between the holder and the debtor, that language ensured that their liabilities would not be discharged in the event of an agreed upon extension.
And counsel, excuse me, was that argument specific to negotiable instruments made below?
So the specific argument about negotiable instruments, and I suppose one could quibble about whether it's an argument or whether it's additional authorities in support of the overall argument about the statute of limitations, but we did not, frankly, Your Honor, cite this negotiable instrument authority or develop this specific sort of strand of our argument. I will note that in our closing brief, we did note the policy underlying the statute of limitations. We said that parties could not contract to defeat the statute of limitations, and we said that doing so would result in all the abuses of the statute of limitations that the statute of limitations was designed to prevent from being revived. And we made very much the same argument in this appeal, but we developed it further. That's our second primary argument. That's our argument that even if you disagree with us on the language of this note. But Your Honor, of course, I would point the court, as we did in our brief, to the Phoenix Lightning Group versus Genlight case. The Supreme Court, I believe, was quite clear in explaining that questions, claims, issues, those are what you waive if you do not make those arguments at the trial court. The question of the statute of limitations has been preserved in this case. We asserted the affirmative defense of the statute of limitations going back to even before this claim was in the case formally, when we opposed the motion for leave to amend the complaint to add this breach of promissory note claim. We filed a brief in opposition to that. We filed a surreply brief. Then, of course, we filed a motion to dismiss. I know that there's some disagreement about whether that constitutes a sufficient preservation, we believe under the Mills case by the Ohio Supreme Court that we cited, Mills against White House Trucking, that it is very clear that filing a pre-pleading motion to dismiss based on the statute of limitations is an independent basis for preserving the statute of limitations issue. And then, of course, we tried this thing in open court. Under Rule 15b, that is independently sufficient to constitute preservation of the issue, because in open court, we tried it, we developed substantial testimony, and we did so with, at the very least, the implied consent of everybody in that courtroom. I would note, I first point the court to page 6 of our reply brief, where we include that chart that we think summarizes where all of this substantial testimony can be found, and I won't rehash all of that testimony here. Well, can I ask actually how much time I have left?
You have 4 minutes and 30 seconds, and you wanted to reserve 3.
Okay, all right, so I'll wrap up in a moment here. But I think if you look at that transcript, Your Honor, the very first thing we say, well, first, after on plaintiff counsel's reasonable suggestion that we offer a blanket denial, because the motion to dismiss had been denied on the morning the trial was set to begin. There was a dilemma. We hadn't filed the answer that they say we needed to file to preserve the statute of limitations. The other side helpfully suggested we tender an oral blanket denial, and that is what we did. I cannot conceive how anyone in that courtroom did not understand that we were asserting the statute of limitations as a defense. We had asserted the statute of limitations at that point for a year and a half as our one and only defense to the promissory note claim. Then, during the trial, and in opening argument, we said, quote, we said that the statute of limitations was, quote, the first issue in the case. And we promised that further testimony would be developed on the statute of limitations issue throughout trial.
This is obviously a little strange because, usually, like you said, there is a written answer and affirmative defenses are alleged, and then there's summary judgment proceedings for statute limitations. It's not tried to a jury.
Right. You're right, Your Honor, and that is why we believe that this should have been dismissed on the motion to dismiss that we filed. We believe that that was the proper period in which the court had all the information that it needed to look at this note, conclude payment was set to begin in 2002. The note was not filed until 2019. That was well past the statute of limitations. That should have been sufficient to, and there was no contention. It was not in dispute that there was never an agreed upon extension of the payment dates. So with that knowledge, we believe at the motion to dismiss stage, this could have been disposed of at that point, and that this should have never even gone to trial.
And counsel, you have about 2.5 minutes remaining.
Sure, I will go ahead. I'll reserve the remaining of my time for rebuttal. Thank you.
Morning. Thank you. May it please the court, counsel. My name is Scott Mulaney. I'm present here today on behalf of the plaintiff and the appellee in this case, Dr. Vladimir. As counsel discussed, the issue on appeal today is whether the trial court properly ruled that the promissory note at issue is enforceable. The defendants have raised a statute of limitations defense, and there is also a secondary ancillary issue involving the payment of attorney fees based on whether or not the promissory note is enforceable. In response to the defendant appellant's comments, as far as the issue is not in dispute, I would generally agree with that. However, we would not agree that the 2003 was the final payment date on the note. It was with respect to the language. However, Dr. Dews, according to his testimony and the determination of the trial court, elected to extend the dates of payment until such time that he made demand for that in or around 2018, 2019.
And counsel, it sounds to me like in the court's entry that election to extend, the court took some pains to note that that was a reasonable election to extend. But is it relevant, the reason why, in the analysis?
Well, I think that the reason why that he extended it, well, let me answer that in two parts. I don't know if under the terms of the note, under the plain language of the note, Dr. Dews is entitled to extend payment of that note without notice to the maker, which was Dr. Moxon and ADMA Products. With respect to why Dr. Dews elected to extend the note, I think that it speaks to one of the issues that council raised was whether or not there was any limiting principle, whether or not Dr. Dews could just extend that note indefinitely. And I don't think that's the case. With respect to the actual promissory note language, it doesn't contain any specific language that states that the statute of limitations is being waived. It allows Dr. Dews to extend payment on the note, but the reasons that he extended, I think, are important in this respect. As this court knows better than anybody, the facts in a particular case are important. And with respect to why Dr. Dews extended the payment, as counsel indicated, the payment initially was due in May of 2002. May 23rd, 2002 is when Dr. Dews was presented this note by the defendant, Vladimir Moxon. Where was Dr. Dews earlier that year? He was in Ukraine. And at that point in time, in May, he uprooted his family from the Ukraine, moved with his wife and his children to Ohio in order to establish a new life in the United States and to work for ADMA Products. At that time, he was presented that note. Dr. Moxon, even though the note was payable in May, starting May of 2002, was immediately in default, did not pay on it. In June of 2002, did not pay on it. I think that you have to take into account the circumstances that were at play at that time. Dr. Dews had just moved to the United States. He didn't have family in the United States to fall back on. He didn't have a friend that he could call. He was in the United States based on an H-1 visa that was supported by ADMA. And if he pursued the note, he feared that that might cost him his employment, that might cost him his standing in the United States, and might necessitate him being sent back to the Ukraine, and thus have to go back to everything that he had left, all the ties that he had already cut. So at that point in time, Dr. Dews elected to extend the note based upon the language, the plain meaning, the plain language that was in that note, in which he understood it to and what the promissory note said.
The counsel, that's what I was going to say. In relation to Judge Hensel's question, people make decisions for whatever reason to not pursue collection, to not make demand, but there still is a statute of limitations in regard to that. And so if he had all these reasons, which may have been legitimate, may have been reasonable, as the trial court said, but how does that necessarily excuse the statute of limitations? That's just the risk you take if you don't demand payment or if you don't file suit or whatever.
Well, again, I don't think that Dr. Dews is in violation of the statute of limitations. As the trial court made the determination that under the plain language of that note, he properly extended. Now, I do not agree that there would be or provide for an indefinite extension of that note. I think what's also important to understand is the relationship of the parties. You're not dealing with a normal banking or commercial transaction with the relation to this promissory note. You're not dealing with bank loaning to company or bank loaning to mortgage lender. What you have is you have an employer and you have an employee. I think there's a fiduciary relationship that is present in this case. And during the terms of his employment, Dr. Dews elected for various reasons in order to extend the term of that note. And the trial court found that Dr. Dews' reasons for extending that note were reasonable. And that included the a duty of loyalty to the company. Also, when the company was financially struggling. One of the reasons Dr. Dews ended up having to leave was because he wasn't getting a paycheck, not a week behind, but months behind. And at that time, again, Dr. Dews did not see it reasonable in order to demand payment on that note. When
Counsel, is there anything in this record that shows that Dr. Dews did not do this extension by secret mental process? Is there anything in here that shows that the extension was known to or acquiesced by Advanced Mental Products?
Well, I don't think, according to the plain language of the note, there wasn't any notice that Dr. Dews had to give to ADMA Products with respect to what his mental processes were. That note was prepared by Dr. Moxon. It was presented to Dr. Dews when he just came to the United States from Ukraine. He wasn't involved in the preparation of that note. He wasn't involved in the negotiation of that note. That was the defendants who now try and use the language that they prepared, that they crafted against Dr. Dews. After he left ADMA Products employment, he promptly brought a claim against ADMA on that note. Once that relationship ended, he brought the claim. I think that there's a whole different situation at play if at a later point in time, if you change the facts, because the facts are important on the case. If all of a sudden we're sitting here 10 years later or 12 years later and Dr. Dews is bringing a claim against ADMA on a promissory note, then as far as the credibility of his decisions to extend that note are going to be suspect. But he ended his appointment with ADMA and promptly bought a claim against ADMA on the promissory note when he realized that it wasn't going to be paid. The trial court reviewed the testimony, and the trial court's review of the testimony should be given great deference by this court. They heard the witness testimony. They heard the reasons why Dr. Dews elected to extend the note, found it to be credible, found it to be reasonable, and based upon the plain language of the note, determined that it was properly pursued and that he brought it within a reasonable time frame after he left employment with ADMA. And Your Honors, I want to touch also one of the main points with the statute of limitation defense. It is our contention that has been waived by the defendants. There's no question that the defendants never raised the affirmative defense in a pleading or in an amended pleading. The failure to raise a statute of limitation in a pleading or an amended pleading fatally waives that defense. That has been confirmed by this court. It has been confirmed by other courts. The defendant raised the statute of limitations in their motion to dismiss the plaintiff's amended complaint. However, a motion to dismiss is insufficient to prevent waiver of a defense not raised in a pleading. Defendants mention the Mills versus White House trucking case. Your Honors, Mills versus White House trucking isn't current law. Jim's Steakhouse versus City of Cleveland, which was decided in 1998, as opposed to Mills, which was in 1974, specifically modified the language of Mills to state that we modify that holding today. And this was modifying holding in a case that had matched the language as referenced in Mills. Noting that Civil Rule 12H applies only to affirmative defenses listed in Civil Rule 12B 1 through 6. Affirmative defenses other than those listed in Civil Rule 12B are waived if not raised in pleadings or an amendment to the pleadings. In fact, Mills made very clear that there is a distinction between the 12B6 argument, which is failure to state a claim upon which relief can be granted, and the statute of limitations affirmative defense. That is why the courts have ruled and followed Jim's Steakhouse that a motion to dismiss is insufficient to prevent waiver of a defense not raised in a pleading. That citation is 81 Ohio State 3D 18. In this case, the motion to dismiss was denied by the trial court. The defendants orally submitted an answer on the record on day one of the trial. Now, counsel suggests that the reason that was done is because plaintiffs had offered that solution to offer a blanket denial of the factual allegations. But if you look at Volume 1, page 4 of the record, Defense counsel states, and I quote, "We would agree with that. That was going to be our proposal," end quote. Defendants, for whatever reason, did not assert any affirmative defenses. On the
Counsel,
record.
I don't remember right now from the briefs, but after the bench trial began, of course, hearing all the evidence, you said opening statement, there was, the defendant mentioned the statute of limitations defense. Was there objection raised at that point by?
Well, there was no objection raised with respect to the opening statement, Your Honor. And what was mentioned in the opening statement was briefly that there's a promissory note. We believe there's a statute of limitation issue, and then, quote, "My clients will provide background on the promissory note," end quote. An opening statement, Your Honor, isn't evidence. It's not something that you submit an objection to.
Well, you can object to the issue even being raised.
Correct, but it had
It's
been.
not necessarily going to the merits, but the idea that he has preserved it.
Well, they also have to present it in the trial, Your Honor. And if you look at the trial testimony, defendant's direct exam of his own client on the promissory note, volume 3, page 191, not even one page, doesn't mention statute of limitations. You can state, Dr. Moxley, is it your understanding that the statute of limitations was waived? You can ask the question, no question was waived. If you look at the entire trial testimony, witnesses, evidence, statute of limitations is not even raised one time. And in fact, still, you have to raise it in the pleading or the amended pleading, which did not happen. Trial took course over the 2 days. After day 1 of the trial, defendants could have submitted a written answer that identified the statute of limitations defense. They chose not to do so for whatever reason. It took 16 months for the trial court to render its opinion. During that 16 months, not once they seek leave to plead in order to file a written answer in order to assert a statute of limitations defense. It's void. It's not there in the record. And as far as any type of implicit consent to try the issue, that's not the case. And in fact, we even stated in our closing brief that it was based, the trial court, and the evidence was based on the plain language of this note, the extension of the note, and that if they try and raise statute of limitations, it was already waived. We raised that asserted that in our closing brief because they never asserted it. Also, I want to touch briefly because I have very limited time, but as far as the other appellate, many of the arguments raised on appeal, such as the misinterpretation of the contract, those have also been waived. Those were never raised at the trial court level, Your Honor. As far as taking different promissory notes from different jurisdictions or off Google or off LexisNexis and stating here's other statutes or here's case laws from foreign jurisdiction in order to explain what this meant. The interpretation of that plain language was never an issue. There were never any questions asked. There was never any evidence taken. They're asking this court to consider evidence that's not on the record. They're asking this court to consider evidence that was never raised at the trial court. That's not permissible for the appellate court to do.
And counsel, I need to let you know that you have utilized your 15 minutes.
I appreciate it. Thank you, Your Honor.
Thank you.
Thank you for consideration.
Thank you, Your Honors. Thank you, Counsel. I'll begin where Counsel started, and that was, I believe, in response to a question asking whether there was any limiting principle to his interpretation of the contractual language here. I did not hear one. I did hear him assert that there was a limiting principle, but I don't believe I actually heard what that principle was, and I don't believe he offered it. And I think the reason why, Your Honors, based on the briefs, based on the trial below, based on the briefing below and the trial court's opinion, is that there is none. Again, his contention, Dr. Dew's contention, is that unilaterally, indefinitely, and secretly, the plaintiff could have extended the payment dates here and with the limitations, period. Haven't
Well,
heard-
at least your client knew that he wasn't pursuing it. If it began in 2002, he never made any request for the payment or said, hey, you're in breach, why haven't you been paying me?
Right.
He knew he was supposed to make payments too. It was not like this was something that was, you know, an agreement that he didn't even know about.
Right. Well, so, and this actually gets to sort of the, I think, the second part of counsel's argument, which is that there are vigorously contested factual issues in this case. I respect the fact that the trial court reached a factual determination on the existence of this note and that the parties entered into this note. But I don't want it to be lost on the court that there are vigorous factual contentions and disputes in this case. My clients here today vigorously deny that they ever entered into this note. And so I appreciate that we did not raise the factual issue in this appeal, and frankly, that's because we understand that what the standard of review is with regards to factual questions, and we didn't think that that was our best argument anyway. But what I heard from counsel mostly was an attempt to relitigate the facts and the reason and the reasonableness of Dr. Deuce's decision to not try to collect on this note. And I would say that there is a whole other story that my clients, if they were at this podium instead of me, would be explaining, including the fact that they gave Dr. Deuce $140,000 when he came to the United States. That's undisputed. That Dr. Deuce used that money to start his life in America, to buy his home, and that Dr. Deuce enjoyed.
And counsel, I need to let you know as well, unfortunately, you have utilized your 15 minutes of oral argument today.
Thank you, Your Honors. Well then, I would respectfully ask this court to reverse the judgment of the trial court. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a decision in due course. The clerk of courts will mail a copy of the decision to all parties to this appeal, as well as it will be posted on the Ohio Supreme Court website. Thank you.